Hello, everyone. Good morning and good afternoon to some of you. Welcome to our second webinar in our commercial litigation series. It's entitled How to Contractually Limit Your Liability. So thank you for joining us today. I'm going to briefly introduce myself and our other speakers. And while I do that, I direct your attention to the information slide on your screen. There's some useful information for you there. My name is Mark Pontin. I'm a partner in the commercial litigation group in our Vancouver office. I'm joined today by two of my litigation colleagues in other offices in Canada. First, we have Karen Wyke, who's the co-leader of the litigation group for our Calgary office. And we also have Vincent, Cérat, Lagana, who's a litigation partner in our Montreal office. We were supposed to have Kimberly Potter with us this morning from our Toronto office. Unfortunately, she had an urgent matter arise on short notice that didn't allow her to be here, but we will continue on, and Karen has bravely agreed to take up the slack. Our webinar today, as the title and the invitation suggests, is really intended to provide you with some practical considerations and some legal updates on ways in which you can contractually limit your organization or you personally, your exposure to contractual damages and other types of losses. And we'll get into that in a moment. One reminder, we would really appreciate at the end of the seminar, if you wouldn't mind filling out our seminar or our survey. That's useful feedback for us and helps us create better content for you in the future. So we ask that you do that. I'm going to be turning it over to Karen and Vincent to get into the details, but before I do that, I'm going to make a couple of introductory comments just to situate the discussion a little bit. So if I could ask if we could go ahead to the next slide. So before we talk about ways to limit liability, I want to start by just getting what is the baseline, what's the starting position. In the absence of a limitation in your contract, in general, a party that breaches a contract can be liable for what is often referred to as expectation damages. And expectation damages are intended to put the non-breaching party in as good a position as they would have been if the other party had completely fulfilled their contractual duties. So the non-breaching party is intended to get the benefits and avoid the losses that they were expecting under the contract. The damages will extend to all reasonably foreseeable losses. So this will include your typical business losses and will encompass a broad range of losses, including lost profits or damages, for example, for the loss of a use of a specific asset. In addition to contractual damages, at least in the common law jurisdictions, parties can also be exposed to concurrent liability for overlapping legal duties. So for liability and tort and equity being the two main ones. So the bottom line, essentially, if you don't have a contractual exclusion, your exposure is potentially wide and to a broad range of typical business losses. If I could ask to go ahead to the next slide. So limiting liability, how do we do this? Of course, parties can, through contracts, reallocate the risks and exposures that they are expecting under a contract. This is perfectly acceptable and is done all the time. There are a number of ways to do this. The three typical ways there are in the slide. The first would be by limiting the amount of the damages that the parties are exposed to. So by putting a cap on the damages, often a cap to the fees paid under the contract or the value of the contract. Can also be done by limiting the liability to certain types of damages that may be suffered by the parties or that are anticipated by the parties. And then a third way is by limiting the types of claims that the parties are entitled to bring in the event of a breach. Next slide, please. So my colleagues Karen and Vincent are going to take you through the three most common contractual provisions that are used to limit liability, and they're set out there in the slide. Karen is going to take us through liability cap clauses, so clauses that cap the limit of the damages that are available. She'll then speak about consequential loss waivers, so clauses which exclude or limit the recovery for consequential losses, and she'll talk about what that means and what that'll include. And then finally, Vincent will talk about liquidated damage clauses. These are clauses that specify specific amounts of damage for specific types of breaches and are usually intended to give some certainty and efficiency to determining what the quantum of a loss is. So with that sort of starting point, I'll now turn it over to Karen to get into the heavy lifting and the details.
Thanks, Mark. Next slide. So the title of this presentation is, of course, how to limit your liability, but you're not always the party that is going to be seeking the protection. So before we launch into caps and some drafting tips and consequential loss waivers, I think as a starting point, it's important to, as you're drafting the provision, understand, of course, if you are going to be seeking the protection of a limitation, or are you a party facing the limitation? And in each instance, of course, you'll have different motivations. And generally, if you're the party that is going to be protected by the limitation, you will want it to be as broad as possible. You will want to ensure that all causes of action and concurrent claims are covered by the clause. Is the limitation included in the contract, and do all the contracting parties have notice of the clause? That's important in more consumer contracts. The other issue, and you might think it doesn't come up, but it does, it's litigated often, is consider who is protected. And we here in Alberta had a case come out of the Alberta Court of Appeal almost 10 years ago now. It was a husband and wife who were building a house on Vancouver Island. They both were building the house, but it was the husband who entered into the contract with the engineer and architect. And the engineer and architect were protected by the contract with the husband by an aggregate liability cap. The trial judge found in that case that the husband had signed the contract as agent for the wife, and so the engineer and architect could avail themselves of the liability cap. But at the Court of Appeal, that was overturned, that it only applied clearly to the husband. And so just make sure you've got all the signatories. If you're seeking protection from the limitation, you want to make sure nobody outside of the contract is going to be able to claim. So, and then of course the opposite is true. If you are facing the limitation, you'll be wanting to limit the exculpatory clause to the extent you can. Don't be worried about the notice, and of course, you'll be wanting to limit the protection to the contracting party only. So next slide. So let's get into one of the most common ways to limit your liability, and that's a liability cap. Often they're called an aggregate liability provision also. You see them a lot, particularly in construction contracts, but also commercial contracts also. They can cap liability for all claims. For example, the aggregate liability of X arising out of or in connection to this contract, whether arising for breach of contract in tort or in equity, is 10% of the contract price. So that kind of provision will, it attempts to limit and all of your liability, whether that's concurrent liability in tort or in equity. Another provision you could add is in strict liability. That comes up a lot for any pipeline or transmission line operator, a Rylands and Fletcher type situation where there can be an escape from your right-of-way that you're liable for. So you would want to add strict liability in there also. But it can also be more specific. The cap can also just apply to breaches of contract. Now, the language here, the liability of X under this contract shall not exceed 10% of the contract price. Under this contract, I've litigated what that means. And so to even be more specific, you might want to add language on that it's not just under this contract, but it's limited to contractual breaches only. Next slide. So are liability cap clauses enforceable? And I will just say as a general note from the outset, the enforceability of any exculpatory clause goes through this three-part test outlined by the Supreme Court of Canada in its case Turcon. And there, like any three-part test, there's some onus swapping at different times. So the party seeking the protection of a limitation of liability must first show that the liability comes within the protection of the limitation of liability clause as drafted. So that first part of the test is, does the exclusion clause apply in light of what the parties intended as expressed in the contract? Now, that is a very intensive interpretation exercise. And we are guided in that interpretation, of course, by another Supreme Court of Canada decision that we litigators rely on often, called SATVA. And so when you're looking at interpreting the clause, you must look at the clause in its entirety, in the contract as a whole, as part of the factual matrix or surrounding circumstances in respect of how the contract was entered into, using sound commercial business sense and principles, and lastly, in light of the purpose of the contract as a whole. And so if I'm the party seeking the protection, I have to prove that that my liability comes within the clause. Now, if the onus then shifts to the other party, if they're to either argue that the clause is unconscionable at the time the contract was made, or if the clause is valid and applicable, there is a policy reason not to enforce. And so what does unconscionable mean? It is generally concerned with leveling an unequal bargaining power. Often arises in consumer type contracts where there are no opportunities to negotiate the terms of the contract. And the doctrine of unconscionability is generally used to invalidate oppressive terms. So a limitation of liability can be set aside for being unconscionable. And then lastly, it can be set aside for policy reasons. And the Supreme Court of Canada in Turcon, when they outlined what those policy reasons could be, talked about serious criminality or egregious fraud. I will tell you that it was a major issue in a case that I litigated recently, where there were some allegations of breaches of the duties of good faith and honest performance. There's been no case law that I have seen that equates a breach of the duty of good faith or honest performance to that kind of serious criminality or egregious fraud, but it's something to be aware of in any kind of litigation setting. If there are those allegations, make sure you're asking yourself if they will impact on any liability protection. So that's the three-part test. There's and it applies to consequential loss waivers also. I haven't seen it applied in a liquidated damages setting, but it generally applies to exculpatory clauses.
And Karen, maybe just before we move on, we were asked a question by one of our attendees about whether there are specific issues that need to be considered with respect to the enforceability of these clauses in the context of consumer contracts and contracts of adhesion. And I know you touched on that briefly. Is there anything more that you can add to that?
Yeah, sure. So we know from the Supreme Court of Canada in, excuse me, in Seidel and Telus, that there's nothing wrong with contracts of adhesion, and that absent a legislative intention, otherwise consumer protection legislation and others, they are just fine. Of course, the unconscionability aspect of the three-part test does come into play in contracts of adhesion or standard form contracts, those contracts where a party doesn't have an opportunity to vary its terms. So definitely they're more susceptible to being declared invalid by a court. I think there are some drafting things that can be done ahead of time to try and insulate those clauses in contracts of adhesion. One would be to make sure that the consumer or contracting party is aware of the clause, that they specifically sign off on the clause. And then also the other is to make sure that the clause is not so oppressive. You don't want to, I think Vincent will be touching on this under the civil law jurisdiction, but the liability clause in a contract of adhesion should not deprive the consumer of the entire benefit of the contract. So the less oppressive the clause and the more attention that is brought to the clause itself, the more likelihood that it would survive an invalidity attack on the basis of unconscionability. But it is an issue. It is an issue for sure. So next slide, drafting considerations, liability caps. For limiting all claims, specify that it is all claims arising out of or in connection to the contract. Also specify the causes of action, whether in contract, tort, equity, strict liability, any cause of action whatsoever. Just keep adding words. That's when you're wanting to limit all claims and you are seeking the protection. Make sure you draft it as broadly as possible. Just on the concurrent claims point too, I just want to make a point as an aside. Of course, there is case law that says you cannot reframe your breach of contract case to allege a concurrent cause of action if the sole purpose of that reframing is to defeat the purpose or the protection of a liability cap. That's a 1986 case out of the Supreme Court of Canada and Central Trust and Refuse. So just wanted to alert everybody to that. So does the liability cap apply before or after set off? I've had this issue come up in a very large construction dispute where claims back and forth are in the hundreds of millions of dollars. And quite surprisingly, or maybe not, there is no case law that specifically says you apply set off first and then the liability cap. What the cases make clear is that it is a matter of contractual interpretation and what the parties intended through their clause. So having litigated that myself, I would suggest that people consider putting the application of set off in as a specific clause in their contracts right around in proximity to the limitation of liability clause. So yeah, be very careful about set off. And similarly, you know, a contracting party, particularly in a huge dispute, is also subject to interest on damages, including pre-judgment interest and post-judgment interest. And on a claim worth hundreds of millions of dollars and a dispute that goes on and on for 5-6 years, you know, interest, and that sometimes under a contract can compound at very high interest rates. You may also want to deal with whether the liability cap includes interest on those damages also. So one last slide on liability caps. There's different considerations, as we discussed, depending on whether you are the contracting party that is protected or you're the one that is limited. They are generally enforceable, but whether they apply is a matter of contractual interpretation. And so, you know, as litigators like to focus on dispute resolution provisions, there are two provisions I go to first in the contract, and I think which a lot of corporate counsel draft last, and that is the dispute resolution provision, and then next I go to the liability cap. So make sure you're precise. The other one last note that we didn't get to in the presentation proper is that there is mixed case law on whether the clause will be interpreted against the party seeking its protection. I think it was understood for a long time that that a limitation of liability would be strictly construed against the party seeking its protection. I've cited their New Brunswick Court of Appeal case, but I think there is a more general approach being taken to limitation of liability clauses coming out of the Alberta Court of Appeals decision in Dow Chemical versus Nova, and that they're really just to be treated like any other clause. It doesn't need to be construed strictly against the party asserting its protection. So mixed case law, depending on which side of the debate you're on, there may be a case that protects you. As far as I know, it hasn't been decided by the Supreme Court of Canada, but there is a movement toward treating them like all other clauses. So moving on to consequential loss waivers. A consequential loss waiver is another form of limitation on liability. Of course, it limits the kind of losses that can be recovered as opposed to the amount. They can be used in addition to or in replacement of other exculpatory clauses. I see in construction contracts particularly, I see both generally. They are designed to prohibit certain kind of losses, as I mentioned, and we've all seen them. They generally look like the example there, and you'll note that they waive indirect, incidental, special, punitive, or consequential damages arising out of or relating to this agreement. The most typical language I see would just be indirect or consequential loss. Sometimes special is thrown in there also. So you know your contract has one if it includes those kind of terms. Next slide. So what is consequential loss? And here has been a bit of a problem, and we'll see in a case we'll examine here in a minute, but there is actually no standard definition of what consequential loss means. It's a special or indirect damages that are not a direct result of a contractual breach, and whether a damage is direct depends on whether they were foreseeable at the time the contract was made. And so depending on the contract and the discussions that were had between the contracting parties at the time the contract was made, different damages are foreseeable. We know from the case, of course, Hadley and Baxendale, if I make it known to my contracting party that a delay in the delivery of my widget will cause me thousands of pounds in damages, then that damage is foreseeable. So it is not consequential loss. I think over the last 20 years or so, there's been a movement, of course, to focus in on what consequential loss means, but certainly I think everybody used to generally understand that consequential loss included loss of revenue, loss of profit, loss of business, loss of production, downtime, reputational damages, but that is not the case. And so the next slide and the case serves as a reminder on the importance of drafting your consequential loss waiver provision. So in that case, between two very sophisticated energy companies, there was a consequential loss waiver included in the contract, and it excluded damages which were the indirect or consequential damages, including without limitation loss of profits and damages arising from loss of production. The court found in that case that the clause only excluded lost profits that are consequential losses, not lost profits that were direct losses, i.e. that were foreseeable at the time the contract was made. And so that was a surprising result for a lot of us litigators, and the trial decision anyway, in Alberta, because despite the consequential loss waiver, the contracting party was awarded a $1 billion judgment for loss of profit. So that takes us to the next slide. Of course, the drafting considerations for consequential loss waivers. We referred at the outset to a boilerplate provision, and it just referred to special, indirect, consequential damages. And as we see from the Nova and Dow case, you need to specify what you mean by indirect and consequential loss. So, all the things that could be included are punitive, aggravated, exemplary, loss of revenue, loss of profit, loss of earning, loss of production, anything you can possibly think of. I would specify that in your consequential loss waiver. Simply referring to consequential loss or indirect damages is risky. And when you list your exclusions, don't use them as an example of the broader category, specifically list them. So last slide on consequential loss waivers before I turn it over to my friend Vincent. The waiver must exclude something otherwise recoverable at law. What is consequential will turn on the facts, and be precise in your drafting. What type of losses are reasonably foreseeable that you want to exclude?
Thank you very much, Karen. That's fantastic. I think that Karen's comments have mainly been from a common law perspective. So Vincent, before turning to liquidated damages, I think it would be helpful if you can take us through some of the differences in Quebec in terms of liability caps and consequential loss waivers, or just limitations on liability generally.
Thanks, Mark. So I always enjoy it when my friends from the other offices in different provinces ask me whether there is a Quebec difference, or or what the Quebec differences are, because the answer is always yes, there is a Quebec difference, and that's certainly applicable to limitation of liability clauses. Before I get started, I will be speaking in English. I saw that there are a lot of listeners that are from Quebec or French speaking. Si vous avez des questions par la suite, des points à clarifier, n'hésitez pas, contactez-moi directement, on pourrait discuter. So yeah, there are differences, and sometimes those differences are not necessarily fundamental, but they stem from terminology and some of the concepts that we use. And the bottom line is that, as for everything, if using boilerplate language that comes from common law provinces to a contract which is governed by Quebec law is just a bad idea, and that is certainly applicable to limitation of liability clauses, especially in a context where such clauses are normally interpreted restrictively by Quebec courts. So it's even more important to draft them according to Quebec concepts and Quebec language. And the place to start, as always in Quebec, is with your civil code of Quebec. And in this case, more specifically with section 14 74 of the Civil Code, which provides that limitation or exclusion of liability clauses are normally enforceable in Quebec. They are valid, they are normally legal, there are exceptions, and 1474 provides for the main exceptions. The first point is that you cannot exclude your liability for bodily or moral injury. So limitations of liability clauses in Quebec will only apply insofar as the injury is material. If we're talking about physical harm of any kind, you may have a clause in your contract, but when it comes time to enforce it, that will not be a possibility under Quebec law. The other point is that you cannot in Quebec limit your liability for gross fault or intentional fault. So intentional fault, that's pretty straightforward. I mean, if you did it on purpose, for instance, false representations, you're not going to be able to exclude your liability. Gross fault, that's a bit of a trickier concept for sure, which has led to different judges applying different criteria to it. I think when it comes to negligence or fault, the way we frame it normally is that there's been a departure from what the reasonable person would have done if placed in the same circumstances. If we're talking about a gross fault, the departure needs to be more significant. Some judges have said that even a stupid person would have shown more care, for instance, than the person committing the gross fault. In other cases, and I think that's probably a useful way to frame it, we're talking about someone who, without breaching the contract intentionally, showed indifference or was uninterested by the consequences of their actions. So it's not necessarily intentional, but it's also not simple negligence. There needs to be a higher standard. And if the party essentially trying to fight the limitation of liability clause is able to show that there's been gross fault, then exclusion or limitation will not be enforceable, even if the clause exists, and even if the clause is found to be actually valid. The other part of the analysis has to be, and that's often the case in Quebec civil law, you have to define what your contract is in the first place, because specific types of contracts may have other rules and may not allow for limitation of liability clauses or may not allow for them in the same way. A good example of that would be contracts of sales and the whole world of product liability, where under Quebec law, you have a number of presumptions applying, presumptions of knowledge for a professional seller or a builder. And essentially, in those cases, you cannot necessarily limit your liability. So the general regime of 1474 would not apply to that, would not apply in the same way to consumer contracts. In the case of a contract of adhesion, which Karen touched on in her part, then it's possible to prove that the limitation of liability is actually an abusive clause, which can be struck or reduced. Employment contracts do not allow in many ways for limitation of liability clauses. Certain codes of ethics are not going to allow a professional to include one. So you need, of course, to look into your specific type of contract to figure out whether you should draft the clause, how the clause should be drafted, and whether or not you'll be able to apply it when the claim arises. Interesting question in Quebec, which was in many ways settled recently by the Supreme Court of Canada in the Prelco case. Can you successfully exclude your liability for something that's the fundamental obligation of your contract? So essentially, I promised you I was going to do this, I'm not doing it, but good news for me, I have this limitation of liability clause and you can't sue me. So ultimately in Prelco, the contract was for essentially the implementation of a system of an office management system. And there were a number of issues in the performance of the contract, and the service supplier was ultimately replaced by someone else to essentially do the job properly. They were sued for all the damages that this led to, but add a limitation of liability clause. And then the question became, you guys just did not do your work, so you should not be able to limit your liability. the Supreme Court found that this was not necessarily applicable, that we should not hold limitation of liability clauses to be invalid, even if they touch on an obligation that's more fundamental. And essentially, most of the key aspects are already found in 1474, especially when it comes to gross negligence, gross fault, or intentional fault. So that kind of set aside a little bit of the controversy, but depending on context, I think, I don't necessarily think that's the end of this question. Another key to contracts in Quebec is that they need a cause. So if the limitation of liability clause essentially makes it so that the contract doesn't have a purpose anymore, then a court may find differently. This was pleaded before the Supreme Court in Prelco, but on the facts of the matter, the Supreme Court decided that there was nothing there in the end. So again, a lot of what Karen said is probably applicable in Quebec when it comes to limitation of liability clauses, but you have to use the framework that we have. Gross fault is a good example of that. Specific rules to specific contract is another one. You will not be able to exclude for bodily injury. So a lot of those particularities that have to be kept in mind. And it's really the same thing when it comes to the waiver of indirect or consequential damages. If you try to limit your liability for certain types of damages in Quebec, what I just mentioned will essentially apply. It's by definition a limitation of liability clause, and those rules will apply to such a clause. However, what's key is that damages from a terminology perspective and also from the way we treat them, they do not work the same way in Quebec as they do in common law provinces. For instance, the notion of consequential damages or the notion of special damages are not necessarily used in Quebec. So in drafting clauses to limit damages under Quebec law, it's important to use the right framework. The framework in Quebec starts with Article 1607, which says that damages to be claimed have to be an immediate and direct consequence of the breach. We move on to 1611. Damages due to the creditor compensate for the amount of the loss that he has suffered, plus the profit of which he has been deprived. And of course, I'm not reading those articles directly, but giving you the general idea. And in contracts under 1613, the damages have to be foreseen or foreseeable at the time of entering into the contract. And again, that rule would not apply, however, if there has been a gross or intentional fault. So clauses that use a lot of the common law terminology and point to consequential damages, indirect damages, special damages may not find echo if your contract is governed by Quebec law, and again, will be interpreted restrictively. So, and Karen actually had a great drafting tip, which is perhaps even more applicable in Quebec. If you want to limit certain types of damages that don't use boilerplate general concepts, but limit those specifically. And a good example of that would be loss of profit. If it's loss of profit you want to limit, then you should say loss of profit. An attempt to capture that concept with consequential damages or indirect damages is risky under common law, as I understand it, but I'd say even riskier in Quebec. So I think that's it. These are Quebec difference, Mark, and of course, in the end, you may end up at the same place on many of those. Our regimes are not that foreign from one another, but terminology and drafting and applying the right concepts is fundamental when it comes to limiting liability.
That's great. Thank you very much for that, Vincent. Appreciate it. I think if we can go back one slide, we can now turn it over to Vincent to start on his liquidated damage provision. Thanks, Vincent. You go ahead.
Sure, and I'll tackle it again from a bit of more of a civil law perspective, and Karen will be able to chime in. It's interesting because when we started preparing for this conference, the topic of the conference was contractual clauses by which we seek to limit our liability. And rightfully so, you guys actually included liquidated damages provisions, but for a Quebec litigator or a Quebec counsel, it's a bit counterintuitive because for us, we have penal clauses in Quebec, and we deal with them all the time, but I never really saw them as an instrument to limit my liability. It's almost more something where I want to ensure that I'll get a certain amount of damages, and it's almost more offensive than defensive in terms of liability. It's I think you guys in common law provinces like the expression, it's a sword, it's not a shield, you know, for us sometimes. But at the same time, it is true that it does limit your liability in many ways, because it allows you to predict it. It allows you to say, you know, I may breach my contract. If that happens, those are going to be my damages, and they're capped and they're clear, and that's all there is going to be to it. So I think the key when it comes to liquidated damages provisions, well, first of all, what is it? It's a clause setting out the damages that will be suffered as a result of a breach, and it acts crucially as both a limit and based entitlement. It's at the same time a floor and a cap, you know. And in Quebec, and I'll get into that, it can also serve a reasonably punitive function. So it's kind of twofold. It liquidates your damages, pre-quantifies your damages, but also can serve a reasonably punitive function. So at least in Quebec, it predicts damages, but acts as a deterrent. It's a way to maximize chances that your contractant will not breach the contract. We can move to the next slide, please. So a crucial point, and something to really think about if you decide to include a penal clause or an LD clause, is that you cannot have your cake and eat it too. In French, on peut pas avoir le beurre et l'argent du beurre. So essentially, if you decide to include a liquidated damages clause, you're going to have to live with it. Meaning that if your damages end up being more than what you had anticipated upon drafting and agreeing to that clause, you cannot turn around and say, well, let's forget about my liquidated damage clause, and I'd rather show the judge and prove my actual damages and get those instead. You're going to have to live with the liquidated damages clause. And as a result, the clause cannot be drafted as optional. It cannot be, oh, well, it's going to be this, but if I can get more, you would maximize your chances of this being invalid or unenforceable. So you essentially have to make your bed in terms of the quantification of damages. The key exception to that, and crucially under civil law, is that in civil law, specific performance or execution in nature is not a poor second choice to damages. It's actually the rule and not the exception. So including a penal clause or a liquidated damage clause will not prevent you from seeking actual execution in nature if the execution in nature is still possible. For instance, it would not prevent you from asking for an injunction, you know. And a key example of that is, for instance, non-competition clauses or restrictive covenants. If what you really want is for the behavior to stop and you're still able to go get a provisional injunction to do that, the existence of a penal clause will not prevent you from doing it. However, when comes time to actually ask for damages, then you will have to live with your penal clause and cannot replace it by actual losses that you may have suffered if those are higher. So there is a risk in using a liquidated damages clause, and it has to be thought through upon doing it. We can move to the next slide. And that's really just a little bit of text from the Supreme Court of Canada. It's a common law case, but completely applicable to Quebec, and really reinforcing that point. The party imposing the penalty should not be able to obtain the benefit of whatever intimidating force the penalty clause may have in inducing performance. So that's the deterring effect I was talking about. And then ignore the clause when it turns out to be to his advantage to do so. A penalty clause should function as a limitation on the damages recoverable, which is why my friends included this in this conference, again, rightfully so, while still being ineffective to increase damages above the actual loss sustained when such loss is less than the stipulated amount. Key reminders, and next slide, two things that must be kept in mind. You still need injury. A cause of action, at least under Quebec law, and whether it's contractual or extra contractual, normally implies that there has been a fault and that you suffered an injury and that the injury is the result of the fault, that there's a causal link between the two. So you're still going to need the injury. If there is no injury, if you're fine completely, 100%, then you may not be able to access, you should not be able to access your liquidated damages. What that clause does, and maybe it's not the same in common law, I'll let Karen chime in, is that what it does is it allows you not to have to quantify your damages, but you still need some form of an injury. And that's very important to keep in mind before jumping into a lawsuit constructed around a penal clause. The other key, at least in Quebec, and that's provided for by Article 1623 of the Civil Code, is that penal clauses can be reduced by courts if they are found to be abusive. And that includes contracts between sophisticated commercial parties. This is not, as would be the case for other clauses, limited to consumer contracts, for instance, or to contracts of adhesion. That's applicable to everyone. If the penal clause provides for damages which are way higher than your actual injury and create a penalty that's exaggerated, then the court retains the discretion not necessarily to strike down completely the clause, but instead to just reduce it and reduce its financial effect to something that's much closer to reality. And perhaps before I let Karen conclude on this part, maybe, and there's a recent case in Quebec which raises an important point. It's important to know, of course, if you're insisting on liquidated damages and you want liquidated damages, then it's clearly a penal clause in Quebec. But sometimes you may draft a penal clause into a contract without necessarily realizing that you were drafting a penal clause. And that happened recently in the Elfin case. It's a Court of Appeal judgment, and it was a shareholder agreement, essentially between two shareholders, in which, and we often see that, and Mark and I practice in that field quite a bit, where you have a buyout clause, an automatic buyout clause. If you as a shareholder employee get dismissed for cause, for instance, you will be forced to sell your shares to me for 20% of their fair market value. And most shareholder agreements actually have that. And what's interesting is that because of the deterring effect of a clause like this on behavior and punitive effect in a way, the court actually considered that this was a penal clause, and the purchase price was supposed to be 20% of the fair market value. But based on what I just told you about abusive clauses, the court said that's too much. The behavior should not have warranted that, and they replaced the 20% or the 10%, I believe it was, by 80%. So then suddenly, as a buying party, you're forced to pay 80% of fair market value, where you exercise an option for 10%. So, this can lead to surprising results. And when you have clauses in any type of contracts by which you're seeking to create a bit of a financial deterrent against the other party, then you have to keep in mind the case law and the articles providing for penal clauses and the exception that allows for courts to reduce those. From a Quebec law perspective, that's what I had to say on penal clauses and liquidated damage clauses.
Thanks very much, Vincent. That is very helpful. And I guess same thing over to you, Karen, to maybe take us through some of the specific things we should be thinking about in the common law jurisdictions when we're thinking of liquidated damage clauses.
Sure, thanks. And Vincent, I find the differences really interesting. There's always a lot that is similar, of course, as you noted in your civil law discussion. Like Quebec law, liquidated damages provisions are considered both a ceiling and a floor in respect of your contracting parties' damages when they're included. I see them most often in construction cases when there is a liquidated damages for delay specifically. Often they are a calculation per day up to a maximum number of days. So we see them a lot in different kinds of commercial arrangements. You often see them where there's a breach of confidence in NDAs and things like that also. So very similar in that way, the floor and ceiling. Also, it does relieve a contracting party of the need to quantify their damages. It's a set amount of damages, but of course you do need to show the injury, just as in Quebec. One major difference is that we would not have the clause upheld in any form if we called it a penalty in the common law jurisdiction or a penal clause. There's some enforceability issues with liquidated damages provisions in the common law jurisdiction, lots of case law on this. In order for a liquidated damages provision to be upheld, it generally has to be a genuine pre-estimate of damages and not a penalty. And where a liquidated damages provision is found by the courts to be a penalty, there's no ability to reduce the amount as there is in Quebec. It would just be struck down as a clause, and then the actual damages would come into play. So some major issues and differences there. When there's some case law, very old case law in Alberta from the 70s that said that when you have a liquidated damages provision, you have to be clear in the provision that it is the sole and exclusive remedy. So for example, for delay in construction, it's worth perhaps mentioning that it will be the sole and exclusive remedy. I have seen contracting parties try to argue around a liquidated damages provision where elsewhere in the contract that there's a provision that says, notwithstanding any provision in this contract, the contracting party has all the remedies available to them at common law. And so whether you're seeking the protection of a liquidated damages provision or any other protection, I'd be scouring contracts and making sure that provision is not contained in the contract somewhere. Obviously, making sure the LDs are a genuine pre-estimate of damages, given the enforceability issues in the common law jurisdiction, is important. A way around that, actually, I've seen is to have the parties contractually agree in a provision close to the LD's provision that the amount is reasonable and a genuine pre-estimate. That is not bulletproof, but it is, I think, a good way to showing that it is a genuine pre-estimate, and also have the parties expressly agree that it is not a penalty, again, to protect against any enforceability issues. Those are all my comments, Mark.
That's fantastic. Thank you both, Karen and Vincent. If we could just go to the next slide, what I'll do here before we wrap is just kind of go over a summary of what I think the key takeaways are from what Karen and Vincent have shared with us, and starting with the starting point. So, obviously, in the absence of a contractual provision limiting your liability, you're exposed to the potential for broad losses for all reasonably foreseeable damages. So without limitations, that all of those reasonably foreseeable damages are your exposure. We've taken you through the three typical ways to contractually limit your liability: the liability caps, the consequential loss waivers, and liquidated damages provisions. As I think both Karen and Vincent have tried to make clear, one clause does not fit all. Karen's point at the outset of her talk about, of course, looking from what perspective are you coming from? Do you want to try and limit these damages? Do you want to try and keep them as wide open as possible? You have to think about your specific situation and draft a clause to meet your needs. But you also need to think specifically about what types of losses you reasonably think may arise, and which ones you need to limit, and which exposures are fair and reasonable for you to limit. The next point, don't overreach. I think Karen talked a lot about making sure the language in your clauses is specific. Try and stay away from broad, open-ended language, as you could end up in enforceability problems. Similarly, with liquidated damage clauses, at least in the common law jurisdictions, do try and make them a genuine pre-estimate of your damages. Don't just try and make them a deterrent, because you may end up in a dispute and in a place where those clauses become unenforceable. And of course, you've then defeated the whole purpose. Finally, keep in mind the differences between your common law and civil law differences, and we've tried to point those out as much as we could, and that brings us to the end of our presentation. But I do think we have a question or two here. I'm just going to quickly look in our Q&A and see if there's questions that may be answered. I don't know, Vincent and Karen, we have a couple of minutes. Are there questions there that you may want to jump in and try and answer?
Yeah, sure. And so we won't have time to answer all of them. One of the questions is, in Quebec, if you do not exclude indirect damages in your limit of liability, are they automatically excluded by the civil code? Yes, however, I'm not sure that's the right way to look at it when it comes to drafting those limits, because again, the answer is in 1607, which says that as a creditor, you're entitled to damages for bodily, moral, or material injury, which is an immediate and direct consequence of the debtor's fault. So there is that notion of direct within the civil code. So the answer in that sense is yes. But direct damages can include a lot of stuff depending on the context. And if there's no other fact explaining the damages aside from the debtor's fault, then those may play in, and they may include loss of profit, loss of revenues, et cetera, et cetera. So again, I think if you are going to draft a limitation of liability, the key in Quebec is probably, and I think Karen mentioned that as well, to tackle exactly the specific damage you want to cover, including, for instance, loss of profit. I will cover you for what you lost in terms. I will compensate you for what you actually lost, but not for future loss of profit. And that's a clause that can be drafted. But the answer, in short, you can find in 1607. Another question is whether we, in Quebec, and the slides do interchange penalty with liquidated damages. Is this because the same rule applied to both in Quebec? I think technically there could be a liquidated damages clause that really has no penalty component to it and really is a genuine pre-estimate of damages. But I think ultimately you would find yourself applying the same two main articles of the Civil Code, which are 1622 and 1623. And if you look at the title under which those are found in the Civil Code, advanced assessment of damages. So in many ways, the goal here, just like in the common law provinces, is to liquidate damages and pre-evaluate them. However, again, there is room to establish a punitive, or I should say, yes, a punitive element in Quebec, but limited room because of the abusive nature that these clauses can have. So those are my comments on Quebec specific questions that I saw in the chat.
And I think we just have time for one last question. I think there was a question about whether we've come across any case law in respect of limitations of liability in a privacy breach context. I have not personally, but it made me think of ensuring that in your limitation of liability clause, why not include a breach of privacy as one of the listed causes of action. It's probably a good idea. Now, I could see there being some potential as far as enforceability concerns, either some public policy or even unconscionability concerns with that, but as far as I know, yet to be litigated.
Thanks to both Karen and Vincent for taking on those questions. And that brings us to the end of our program today. So thank you, everyone, for joining us. Just a quick reminder to please fill out the survey if you haven't done so. As I said at the outset, that it's useful feedback for us. There will be one final webinar in our commercial litigation series that's going to be coming up in April. So keep an eye out for that in your inbox. We'd love to have you back. If you are interested in other Fasken events, I would recommend you go on to our Fasken website and look in the Fasken Institute section and register for any events that are of interest to you. And with that, thanks very much, and thank you for joining us, and have a great rest of your day.